needs to be complied with. Number two, Mr. Speaker, I see no hurry in chasing you away a colleague because you are the Speaker of this House. So Senator Mwaura is our colleague, is your colleague. And finally, Mr. Speaker, I want to go on record that this is a travesty of justice, whatever decision you take. And I hope the people of Kenya are taking notice of how we are observing the constitution that they passed. And if we are disregarding this constitution, nothing will prevent us from even undermining the amendments that we are considering this afternoon. Thank you, Mr. Speaker. I beg you, respectively, to reconsider your decision.
Senator Cherargei.
House has to comply with the court orders. And I raised this issue when we had a court order in the matter concerning the impeachment of the governor for Taita Taveta. And the House declined to obey that court order. And court orders are court orders. You cannot choose which one to obey or not. You cannot begin to now argue that this is legislative, this is what. In accordance with Article 10, a court order is a court order. And I still believe that if you want to become a nation governed by laws, then the first principle is to obey court orders. And we have not been faithful to this fundamental requirement of the law. Even this Wajir case, we have got a court order. And we said Parliament cannot be injuncted. I don't believe Parliament cannot be injuncted. Parliaments are injuncted worldwide. Even the House of Representatives, the Senate in the United States, there are a lot of court orders that are issued against parliaments. In the European court, in the Supreme Court of England, there were proceedings challenging active proceedings in the House of Commons, in the House of Lords and the House of Commons. It was presided over by a very honored Lady Chief Justice. And the orders, Parliament was injuncted, and the issue remained there until the appeal process was completed. So what I'm pleading with you, you cannot choose, you cannot elect and choose which orders to obey and which one not to obey. Right now, we got orders against the National Assembly, and the National Assembly is complying with those orders in the matter which is in the Court of Appeal. But we are on record here saying, you know, court orders mean nothing. I think it's a very unfortunate state of affairs. Not even during the Kanu rule would somebody say that you cannot obey court orders. That is number one. I think you've got to blame yourselves. You have said on record, in fact, Your Honor, Mr. Speaker, I was writing some article based on the two decisions which are here. And you remember Speaker Kindike made what was called a landmark ruling, where he said we cannot obey court orders. That is on record. That is on record. And I believe on questions of human rights, they are so fundamental, they are so central to our system of constitutionalism, that whenever there's an allegation, even a threat to a violation of fundamental rights, the courts can intervene. I remember in South Africa where the parliament in South Africa was trying through committee a member of the minority party, which was the Nationalist Party, the Democratic Party. And parliamentarians say, no, you can disregard court orders. We want to kick that member of parliament out. But the High Court sitting in Cape Town intervened, and Parliament was injuncted. So what I want to say, Mr. Speaker, we got to be consistent. We should settle this question. whether court or orders matter or they don't. That question we have not settled. So when it pleases us, we say there's a court order. When it doesn't please us, they say court orders can go to hell. We have to be consistent. Number two, Mr. Speaker, we have now two sets of documents. A letter from the lawyer purportedly serving your office with a court order. And that letter is dated today. And there's another letter dated, I think, 10th of March. I can't read it properly. Now, all these papers should be placed before you. And I have a lot of sympathy for Senator Mwaura. I can even go and intervene for him in court, just like I intervened in the case of Senator Wetangula when he was being removed maliciously. And in fact, that one he was being removed by an order of the court. And we argued and said that the court order was not good enough for his removal. And I think Senator Wetangula would confirm that. And even this time, I am ready and prepared. Last week I made a speech here and say, you got a right to protect me and I also have to protect you. So this is one of our own. We should find a better way of protecting him. Now, Mr. Speaker, the only problem that you have now is that there's a Gazette notice. And Senator Waku will tell you, in law they would say you're functus officio. The law does not allow you to recall your decision in matters like this when it is already gazetted. But I think I know how this decision can be recalled, not by you. No, because it's a functus officio. Yeah, he can't. That's a fundamental principle of law. Once you have made a decision, and I think Professor Ngindiki knows that in these circumstances you're a functus officio. You cannot pretend to be doing anything. You'll be in a lot of trouble, even you, if you are to revise this decision, which you have already made and is gazetted. So what I will plead with, and I had a little discussion with Senator Mwaura outside. Let me be open. And I told him exactly what should be done. But pleading here with you, I think is lamentation in these kind of circumstances. I think you better get all the papers, see when you are served. Was it before this Gazette notice? And the order of stay, what does it say? Is it staying your decision? Or what is it staying? So we need to get all these details for you to make a decision. But I plead that we should sit together, because Mwaura is one of our own, to find a way to help. But we are not going to help by pleading with you when the thing is already in the Gazette notice. Not even the President of the Republic of Kenya can do that, by the way. Once he gazettes something under an instrument of the law, it is over. I thank you, Mr. Speaker.
My colleagues who have extended a heart of sympathy to Senator Mwaura, who is fallen victim of the implosion in his party. Mr. Speaker, Senator Orengo has put it very well. When I was maliciously pursued to the extent where the Supreme Court directed that my name be struck off the voters' roll and directed IBC to effect the order. First, my case is slightly different. Nothing was gazetted. But we went to the IBC. They formed a tribunal chaired by lawyer Letangule, Mrs. Mahiri Shaja, and there's the gentleman from the coast. What is his name, Faki? Alawi. And they made a decision that was probably more sound than decisions we get from the High Court. And they protected my rights. my rights having won openly and convincingly in an election to be taken away by some malicious pursuit. And Mr. Speaker, in this particular case, I share the same views with Senator Orengo. One, you've made a communication from the chair, which you say you have been advised by Senate lawyers, and you have quoted a Gazette notice. Mr. Speaker, I can tell you that in law, if you try to reverse your decision, you'll be in serious trouble. Serious trouble. And I don't think you have made that communication either maliciously or ignorantly, because you have quoted the Gazette notice. What I want to advise Senator Cheriot, my good friend, Senator Murkomen, who can give pro bono services to Senator Mwaura, my distinguished colleague Kindiki, a fine lawyer in his own right, who traces his roots in law, partly from me, Mr. Speaker, that the best you can and should do is, one, look at the Constitution. It says you cannot be disenfranchised until you have exhausted all the machinery and the steps of appeal. I don't know if Senator Mwaura has exhausted that. Number two is to go to court and fight ferociously. And some of us who stand for rights of others are available, if we are requested, to lend a hand and our brain to expunge and annul the Gazette notice. Because neither the government printer, nor the Speaker of this House, nor any person other than the High Court can expunge that Gazette notice and go back to the status quo ante. Then Senator Mwaura's position will be saved. So we can debate here, Mr. Speaker, for the next 1 hour and say a lot of things with very colorful language, quote the law, quote Shakespeare, quote Greeks, quote everybody. But Mr. Speaker, eventually, it is a matter of application of the law. And I agree with Senator Orengo that we need finally to agree as a House. Do court orders matter or not? Senator Cheriot, you avoided to mention that it's me who said here last week that this House has benefited immensely from court processes. It is me who said that, and I dare say that our advice or opinion and our several forays in court is what has given dignity, standing, presence, and respect to this House. Otherwise, we would have been overrun. We have enemies from every direction, but courts have been our first and last line of defense. Thank you.